And what about Central Cooperative Bank? Dhanbad Central Cooperative Bank?
I have given.
You have filed your affidavit?
No, I also seek most time.
It's a very serious matter. If you do not file your affidavit, we'll ask the petitioner also will have to appear in person, and your officers will also have to appear in person. Don't put your officers and the petitioner in an embarrassing position before them. You can't run away with the money like that. This matter is pending since 2014. And if the whereabouts of the money is not known, we have to institute an FIR.
And indulgence will be granted, will do the needful manner.
The FIR will be instituted, don't worry about it. You can't run away with public money like that. Everybody will be booked. We'll take action, very serious action. Out of 17 crores, we have returned only about 1 crore. You have not taken any steps. NABARD has not taken any steps.
Since case is pending and
so you sleep over the matter.
we are only writing letters and they are.
That serves the purpose.
No, that.
You got a court's order. You need a court's order to take any action.
However, it is not compulsory. We should have proceeded.
Okay, WPC number 1450 of 2014. Counsel for the parties are present. Learned counsel appearing an affidavit in terms of order dated 13/10/23 has already been filed by the respondent number 1, the petitioner, as well as the counsel for the petitioner, as well as the counsel for respondent number 3 and 4 pray for and are granted time till 8th of December 23 to comply the order dated 13/10/2023. In the meantime, they may respond to the affidavit filed by the respondent number 1. Post on 15th of December. आपको कॉपी मिल गई? You have received the copy of respondent number 1?
Attend meeting CMP 190 of 2019.
Yes, what is it?
For restoration of the civil review 29 and 15. Last date is petitioner is not appeared. 16 order mechanism 16/10.
You have filed wakalatnama on behalf of opposite party number 5 to 12. And what about the rest of the opposite parties? You sought adjournment to file wakalatnama on their behalf.
सबका लिख फाइल कर
5 to 12, no?
On behalf of the state respondent,
You have filed wakalatnama on behalf of 5 to 12.
state council.
फाइल 12
I want to put a state only.
What about 1 to 4?
Yes.
Sorry, 1 to 4.
is state
I have nothing in that.
1 to 4 is the state respondent. 5 to 12. They are seeking restoration of civil review petition. What is the reason? Was it dismissed for default?
this is withdrawn.
Withdrawn?
The CMP WPC was dismissed as withdrawn as subsequent development has made.
Who is the counsel for the petitioner in this matter?
Last date you have not the last chance of given by the single court will on 16/10.
No, last time somebody was appearing, Mr. Prashant, no.
No,
Learned Council.
on 16/10 total order will kindly see madam.
6/11.
6/10 total.
6/10. By way of last attendance. VKCMP number 193 of 2019. Nobody appears on behalf of the petitioner. The learned counsel for the opposite parties are present. On 6/10/23 also, the counsel for the petitioners was absent and the matter was directed to be posted today by way of last indulgence. In view of the fact that nobody is appearing on behalf of the petitioner, the present petition is dismissed for now. थोड़ा देर रहिएगा, जाइएगा मत, अभी हो सकता है petitioner के वकील साहब दौड़ के चले आए।
Item
Wait for
19.
some time, है ना? थोड़ा देर रुक जाइए।
Item 19 CMP 888, 881 of 2019.
The mediation is paying for an adjournment in this case.
Why do you need that then?
Because my senior was appearing on behalf of the petitioner, it's not going to be.
Oh, petitioner?
Yes, mediation. You have to transfer the form.
Study state. Fresh wakalatnama is to be filed.
Some other officer will appear in this matter.
No, you have to file fresh wakalatnama. This is
CMP for restoration or
maybe restoration. There is a wakalatnama and the counsel who is there on record cannot appear. So you have to file fresh wakalatnama. It's a local matter, file fresh wakalatnama. You have been instructed to appear in this matter.
yes.
CMP number 881 of 2019. MS, your name, pura naam.
Miss Diksha
Diksha
Divedi.
Divedi. Advocate submits that she shall file a fresh wakalatnama in the present case. When should I post it? 8th December?
Yes.
Post on 8th December.
Item 20 CMP 441 of 2022.
This application is for restoration of WPS number 4878 of 19, which has been dismissed for non-compliance of order dated 27/4/2022.
Regarding removal of defects?
Yes, I had made a prayer to file an IA for ignoring certain defects, Your Worship. Thereafter, I filed the inspection slip and noted on the survival defects, communicated it to the petitioner, and in the meanwhile, the time lapsed and the petitioners came subsequently since they were from the different places. Reasons stated in para 9 to 11.
Otherwise, you are now ready for
Yes,
removing the
yes,
defects?
yes.
Any objections?
Only for.
Sorry?
No.
You should not forget that we are on live stream. So be very careful in making your submission. CMP number 441 of 2022. Counsel for the parties are present. This petition has been filed for restoration of the WPS number 4878 of 2019 to its original file, which stood dismissed for default on 13/5/2022 on account of non-compliance of order dated 27/4/2022 regarding removal of defects. The learned counsel for the petitioner submits that the defects could not be removed within the stipulated time, and a petition was filed for ignoring certain defects. But before the petition could be taken up by this court, the stipulated time for removal of the defects had already expired. Counsel for the opposite party has no serious objection to the prayer for restoration. After hearing the counsel for the parties and being satisfied with the cause shown by the petitioner regarding non-compliance of order dated 27/4/2022, the order dismissing the case on default on 13/5/2020. The order dated 27/4/2022 passed in WPS number 4878 of 2019 is hereby recalled, and the writ petition and the aforesaid writ petition is restored to its original file. Post this case under appropriate heading, post the writ petition before the appropriate bench as per roster in the month of December 2023. The CLP is
Item 21, CFP 194 of 2023.
Restoration for WPS number 2815 of 2013, dismissed for non-prosecution. In para 6, I have mentioned the reason due to inevident mistake it could not be marked, and that's why it has been dismissed.
Any objection from your end?
No.
Counsel for the parties are present. This petition has been filed for restoration of 2815 of 2013, which was dismissed for default due to non-prosecution on 19/9/2022. The learned counsel for the petitioner submits that the counsel for the petitioner did not appear on 19th of September 2022 when the case was called out, as due to inadvertence the list could not be marked. The learned counsel appearing on behalf of the opposite party has no serious objection to the prayer for restoration. After hearing the learned counsel for the parties and being satisfied with the cause shown by the petitioner in connection with non-appearance on 19/9/2022, the aforesaid order dated 19/9/2022 passed in WPS number 2815 of 2013 is hereby recalled, and the aforesaid petition is restored to its original file. Office is directed to place the aforesaid petition before appropriate bench as per roster in the month of December 2023. The CFP stands it. Next.
Item 22, CFP 711 of 2023.
May I please, Your Lordship? Lordship, praying for not today. On the earlier date, there was a direction for filing of a supplementary affidavit, and it has not been filed. Praying for not today. Any date may be given, Lordship. It will be filed.
Supplementary has been filed, I suppose.
No, Your Lordship. There was a direction for putting the name of the advocate.
Okay. All right. Now you have a changed counsel.
Yes.
You have to present.
Yes, Your
When do you want it?
Your Lordship, any day.
On the request of the learned counsel for the petitioner, the matter is adjourned and is directed to be posted on 8th of December.
Obliged.
किसी पार्टी और खाली कॉपी के लिए
You provide him a copy. He'll give you the copy.
Item 23, CMP 923 of 2023.
Yes, petition.
May I please arrange? Lordship, the CMP has been filed for restoration of WPS number 2236 of 2019. It's to dismiss on default on 4/11/2022 for non-compliance of the preemptory order dated 17/10/2022, which is appealed 14 years.
This is regarding removal of defects.
Removal of defects.
Why didn't you remove the defect?
Your Lordship, this was filed from a different office, and the memo at page number 16 would show that. The previous counsel's name at page 16. And thereafter we have mentioned from paragraph 7 to paragraph 11 the delay that was caused by the petitioner taking legal advice and approaching us.
CMP number 923 of 23. The legal counsel for the parties are present. This petition has been filed for restoration of WPS number 2236 of 2019, which stood dismissed for default on 4/11/2022 due to non-compliance of preemptory order dated 17/10/2022 on account of non-removal of defects. The learned counsel for the petitioner has submitted that the petition was being handled by another counsel, namely Mr. Shrestha Gautam, whose name is appearing at Annexure 2 to this petition. And after the petition was dismissed, the present petition has been filed by another counsel. Therefore, she is not in a position to give concrete reason for non-compliance or non-removal of defect within the stipulated time. The learned counsel for the opposite party has no serious objection regarding restoration of the writ petition. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances of this case, and in order to and the nature of dispute involved in the writ petition, the WPS, the order, the writ petition, being WPS number 2236 of 2019 is restored to its original file subject to payment of cost of ₹5,000 to be deposited by the petitioner before the Jharkhand State Legal Services Authority. The receipt of deposit will be filed before this court prior to 8th of December, prior to 5th of December 2023. If the cost is deposited, the office is directed to place the writ petition before appropriate bench as per procedure.
Congratulations.
Item 24, CMP 1023 of 2023.
Yes.
For restoration, Your Lordship, the writ was dismissed for default for non-compliance of order dated 27/4/2022, Your Lordship. That order was for removal of defects in the writ petition, Your Lordship.
Why didn't you remove the defects?
Your Lordship, the petitioner is living in a remote village, Your Lordship. They could not communicate and hence the defects could not remove, Your Lordship.
What is the reason mentioned in your petition?
The-
Tell us what is the reason for
It's the
non-removal
same
of
reason, Your
defect
Lordship.
mentioned in the
The same reason, para
Where is
number 4, Your Lordship.
para number?
Petitioner was not able to get into contact with the council of petitioner or the clerk of the council.
Petitioner number is not able to contact.
It is written.
You became restless.
Lordship. No, we were not able to get into contact.
Read it, please.
Yes, Lordship, that is
Para.
given written.
Read para.
That the registry has pointed out certain defects in the incident matter which could not be removed by the petitioner as the petitioner was not able to get into contact with the council or the clerk of the council.
How is it possible?
It is written just the opposite, Your Lordship.
So some cost.
But the reason is that, Your Lordship.
Some cost is required.
It may
Such
be
kind
ignored.
of statement is not acceptable.
Lordship, it may be ignored, Your Lordship. Is a dismissed police
We will
council.
ignore it. We will
I mean,
surely ignore it.
They cause
But
you
subject
to ignore, Your Lordship. Because the petitioner has been
that is the
dismissed, Your Lordship, from the
prerogative of
service,
the
Your
court.
Lordship.
You overburden the court by unnecessarily not removing the defects within
The
the time.
defect which will.
And you make a statement like this, which shows that as if the advocate had become restless.
No. If I may, Lordship,
CMP number.
this one, Lordship, the defects which were supposed to be removed by us
See, I
Lordship,
hardly-
without filing any document, Your Lordship, that has been removed, Your Lordship.
We do not know. We do not know what has been removed, what has not been removed. But it will be restored only upon payment of cost. Had I been in court number 2, the cost would have been 50,000, but I will only say 5,000.
Lordship, that is. It's a dismissed constable, Your Lordship.
Yes. So he is all the more.
Lordship is dismissed, Your Lordship. And he is dismissed on very
CMP
big grounds,
number.
Your Lordship.
I know. So you should have been serious about it. CMP number 1023 of 2023, counsel for the parties are present. The counsel for the this petition has been filed for restoration of WPS number 2250 of 2019, which stood dismissed for default on 13/5/2022 on account of non-removal of defects within the stipulated time granted by the order dated 27/4/2022. The learned counsel for the petitioner has submitted that the petitioner stays in a remote village and therefore he could not be contacted for the purposes of removal of the defects. However, he has also submitted that it has been inadvertently mentioned in paragraph 4 of the petition for restoration that it was the petitioner who was unable to contact the council or his clerk. The council submits that the matter relates to dismissal,
Yes, Your Lordship.
and if the writ petition is not restored, the petitioner would suffer irreparable loss and injury. Counsel for the opposite party has no serious objection to the prayer for restoration. After hearing the counsel for the parties and considering the facts and circumstances of this case, this court finds from the writ records that time was granted on repeated occasion to remove the defects. But in spite of that, the defects were not removed. the counsel for the petitioner had not even appeared before the joint registrar judicial, had not even appeared before the registrar general on 16/8/2019 for removing the defects by the time for removal of defects in the writ petition was granted on 10/7/2020, 4/1/2022, 25/2/2022, and also 25/2/2022. Considering the totality of the facts and circumstances of this case and the fact that the matter relates to dismissal of the petitioner, that the writ petition relates to dismissal of the petitioner, the WPS number 2250 of 2019 is restored to its original file, but subject to deposit of cost of ₹5,000 by the petitioner before Jharkhand State Legal Services Authority. The receipt of the deposit be filed before the registry by 5th of December 2023. If the receipt is filed within the stipulated time, the writ petition be listed before appropriate bench as per roster, CMP is accordingly allowed in the
If I may, Lordship may take a lenient view.
I will not. I have already taken enough lenient view.
I'm just saying that the
10 is missing.
But that is the division
See,
bench, Lordship.
So division means so there should be one more zero here. That is fine.
It is a dismissed employee, Lordship.
I know.
Item 25, CRNP 1.
I just don't like non-serious persons. Even if the advocate is non-serious, I don't like it. Yes. Yes.
So, additional family court actually has directed both the parties to file a petition of correction in the order dated.
Correction. You are for the petitioner?
Yes.
Okay. Has directed what?
For correction in the Lok Adalat order dated 8/12/2018. The rectification is from Family Court Jamshedpur to Family Court Ranchi.
Have you filed any petition?
Yeah.
Where is that? Where is the petition?
फाइल हुआ है मैम जमशेदपुर में मैंने यहाँ पे फाइलिंग हुआ था
What prayer? What is your prayer?
मैंने ये divorce तो फाइल divorce.
What is your prayer in the main
My prayer
petition?
is that there is a rectification in the order dated 8/12/2018. In the rectification is from Family Court Jamshedpur to Family Court Ranchi, and और एक है कि 10 lakh rupees.
I don't understand your prayer. What prayer have you made in this petition?
Ma'am, the prayer.
Who is the private respondent?
Ma'am, respondent नहीं हूँ मेरे ही case में.
So you are the petitioner or the respondent?
Petitioner.
You are the petitioner. Has notice been issued to the private respondent? Let the notice go. There are defects in your petition. Why don't you remove the defects?
Defects to remove हो गए थे.
Let me just find it out whether you have removed the defects. Is it defective? It's not defective? Let me check. We'll issue notice to the private respondent.
मैम और वो बेटी के लिए मेंटेन
Sorry?
करने के लिए मैम बेटी को मेंटेन करने के लिए चाइल्ड को 10 लाख रुपीस का भी ऑर्डर लगा था कि बच्चे को मेंटेन हेल्थ और एजुकेशन के लिए उसको बहुत
So
जरूरत
होगा. Let the other side come.
जी.
This is now CMP or CRMP? CRMP number 1511. 1511 of 23. The petitioner is appearing in person. Issue notice to the opposite party number 2 under registered cover as well as bid post, for which recusals be filed by 6th of December. Okay. Is that okay? You want it earlier? 29th of November? 29th of November. Pose this case on 21st December 23, awaiting service. You can serve Dasti in addition. Just a minute. Post on 16th December. 16th. 15.
Item 26, CRMP 2732 of 2023.
After the deposited due to the charge, that is required for revalidation. One-time settlement, 45 lakh rupees was to be paid. Some amount has been paid, but some amount was deposited with the registrar general. And the
You are appearing for whom?
For respondent here.
Which respondent?
Rafi Kumar.
Respondent number, which party number 2?
Opposite party number 2.
Notices were issued.
Notices were issued.
Okay, so what do you want?
Lordship, we have no objection about the revalidating of the deed, but there is just one request from Learned Court as well as the Learned Council of Petitions that the deeds may be submitted before the Learned Family Court at the time of recording of the deposition of the parties.
No, when you complete your everything, let it be deposited here. If you come after everything is complete, the amount will be released.
It was just for the sake of convenience of the parties, nothing else.
What is going on there?
Ma'am, second deposition of the parties is still pending.
What is going on over there?
Second motion, Your Lordship.
Divorce. Mutual divorce.
Where is it pending?
Family court, additional family court to Ranchi.
Additional
Principal Judge Family Court.
Principal Judge Family.
Additional Principal Judge Family Court.
What is the amount?
It is around 9,80,000.
It has been deposited before the restart. You want it back?
Yes, Lord, it has expired, already expired. For revalidation, so that the money can be paid to the opposite party number.
You can do one thing.
Yes, Lord.
That after revalidation, you deposit it back to the registrar general. I'll keep this matter pending, and once that DD is deposited, then we'll ask the registrar general to remit the matter in the account of the family. Or you want to deposit it straight away?
After divorce, you can
The DD is in whose name?
the opposite party number 2,
Oh, it is in the name of opposite party
Yes,
number 2?
yes.
Not in the name of registrar general?
No. May make a suggestion. After divorce, you can take it from the office of the registrar general, that can also pass.
Your Lordship, for passing of decree in 13B, all the matters has to be settled between the parties, which include the one-time settlement amount and this case also.
So you are more comfortable taking it from the family court? The learned counsel for the petitioner, you are for the state?
Yes,
Any objection to the prayer made? Learned counsel for the parties are present. This petition has been filed for modification of order dated 10/5/2023, passed in criminal revision number 51 of 2021, only to the extent that the demand drafts of rupees 9.80, which has been deposited by the petitioner before the learned Registrar General in view of one-time settlement arrived at between the parties, between the husband and wife.
Yes.
Between the husband and wife be provided to the petitioner for revalidation, as all the drafts have expired Nothing has been mentioned over here regarding your family court case number, etc. is not mentioned.
Because it was mentioned in the compromise petition, all the things were mentioned.
The learned counsel for the opposite party has no serious objection to the prayer made after hearing the counsel for the parties and considering the facts and circumstances of this case. The learned Registrar General is directed to hand over the demand drafts, which is said to have been deposited with him, total amounting to total of rupees 9.80 lakhs, and the petitioner is directed to redeposit the same before the learned Registrar General by latest by 29th of November 23. अब ये पे जमा करिए. We can't, in absence of any such prayer, any such details on record, we are not going to pass any order. Okay? Particularly when a party is appearing soon.
Not in the order itself, is at page number 14. What's it? Observe. Page number 14, paragraph 30 It is not in dispute that an amount of 35 lakh 20,000 has already been received by the wife.
No, that's right. Yeah, I remember the case.
Yes.
The order dated (10/5/23) as in criminal division number 76 of 2019 is modified to their proceeding state. We have not stated anything about it. Nothing has been mentioned. Okay. This petition is disposed of.
So from the Registrar she will.
First you deposit it. After that deposit, you take a receipt of the deposit, file it before the learned court below, get your matter settled. Then he will file a petition for withdrawal. I will allow it.
Okay. Okay.
Article 27, DA 8427 of 2023.
Yes, petitioner.
It's great for grant of regular bail. First bail application, since the co-accused has been allowed bail by your lordships, that's why this has come before your
What is the
lordships.
stage of the case?
Yes, my lord. The only charge sheet has been submitted, my lord, that the director
When
was
was the
given
charge
to
sheet submitted?
director was given to the state council once to file counter affidavit in this case earlier. That is by an order dated 6 October 2023, and they have filed in counter affidavit. The counter
What
affidavit.
is the allegation against you?
Against me, there is no allegation because the first information report was lost against unknown persons. As per the case of the prosecution, that this is left the house, thereafter he returned, and subsequently his dead body was found, and accordingly the first information report was lost against him.
The case was against unknown.
Unknown. Earlier, some of the co-accused were apprehended, and they confessed.
Dilip Mehta.
Dilip Mehta. As per the confession of the co-accused, Badal Khadia and Karma Urao, the petitioner has been made an accused in this case, matters. Earlier, the charge sheet was submitted against them, matters, not against me. That is also apparent from the
What is the
counter
date
affidavit filed by the
What is the date of filing of the charge sheet?
charge sheet. he surrendered my lords on 26th of
That I see.
September.
What is the date of submission of charge sheet? So far as you are concerned.
24/5. No.
He surrendered my lords on 26th.
What is the date of submission of charge sheet against the petitioner?
Final form has been submitted also. 30/7/2020.
Final form.
Yes.
And how does he become a...
Lack of evidence, because lack of evidence.
So why has he been taken into custody?
No, he has not been taken. He surrendered my lords. He surrendered.
Maybe if there is lack of evidence or if it is a case of no evidence, then under such circumstances, why will he be taken into custody at all?
No, he cannot be.
He cannot
Then you say final form was submitted.
Perhaps it's a wrong submission. It's not correct submission.
Mr. Counsel, are you serious about it?
That is mentioned in the counter affidavit. Perhaps it is mistake in mentioning the fact. The charge sheet was submitted against others matters.
When was the charge sheet submitted against you?
Must be in the month of October.
We do not know. You do not know your facts. Okay,
Charge
BA
sheet
number,
was-
we can't do anything about it. BA number 8427 of 2023. It is the counsel for the parties are not in a position to inform this court as to when the charge sheet has been submitted against the petitioner. Counsel for the parties seek adjournment, pose this case on 8th of December. This fact we brought, this fact we brought on record by filing supplementary affidavit by the opposite party state office is also directed to call for a report from the learned court below regarding the present stage of the case.
For final disclosure, item 1, CRMP 694 of 2011, along with item 2 to 4.
Yes, what is it? Your filed a compromise petition?
We are not filing a lordship. Actually, Mr. Nathru Bhajanka is in and is admitted in the hospital. Rather, for that purpose, I had already requested that since he has to come down from Surat to Ranchi and joint petition has to file. For that purpose only, I requested that a time will be taken in motion.
Why
So
do you
the-
burden the court like this?
Beg apology.
Why should he come to Ranchi?
And that's what I have requested that he can get us.
He is OP number 2, the informant of the case.
We only enter into a compromise for the Jharkhand.
Is it possible that if he is not in position to come to the Ranchi, then his one affidavit from Surat or wherever he is residing?
No, we will not permit that. Not in a criminal case like this. He is not wanting to come now.
He can come. The lordship he has sent me a case there. Right now moving to Bangalore also because of his illness. We just signed the admission letter. So one accommodation maybe be posted in somewhere in month of December. He has assured me that he will be coming. Mr. Sharma is also supposed to come. Mr. Sharma, the previous advocate, was preparing. So this is the only information I got in the morning today.
You have paid the cost?
Yes, I have paid.
Where is the receipt? Where is the receipt regarding payment of cost? Deposit slip, Charles.
Yes, this is also reflecting in the status.
Okay, done. You can't keep the matters of 2011 pending like this.
One last. We won't be taking because he has assured me they will come. So because of his illness, he could not come. That's not 78.
Counsel for the parties are present. Counsel for the opposite party, number 2 in CRFP number 694 of 2011, submits that the opposite party number 2 is ill and therefore he could not come to this court to swear the affidavit regarding joint compromise. The counsel seeks adjournment.
Any date in the month of December, because till 24th is there in Bangalore. That's right.
Post on 8th of December. 8th December.
Lordship, it could be the 3rd week of December. Because he is coming back on 24th, 25th.
I just
Just Lordship.
no, you only said any date.
Any
When
date.
you say
I
any
request-
date,
I
then
request-
you change your own statement.
No,
You are not serious about your statements.
I'm serious. Lordship,
You said any date in the month of December.
Lordship, in the 3rd week, things go.
15.
15th.
15 December.
15th.
My appearance limited in the first
You give your appearances.
Item 5, WPS 2644 of the Napoli.
Yes, what is it?
Dismissal from service member. May I start?
What is it? Yes.
In pursuant to last order, I find the source and also list of dates in my written manner and the judgment also, which I am going to know.
This is your list of dates.
Yes, sir.
So what is your point?
Main point, my lord,
You were working as constable.
I was working as a constable. I was during a night checking. I was found absent, and therefore a charge was framed, my lord, that I remained unauthorizedly absent from service. Thereafter, departmental proceeding was initiated. In the departmental proceeding, the inquiry officer deviated from the charges, and what was not in the charge, he considered all those aspects and recommended for and hold me guilty, my lord. Thereafter, disciplinary.
What was not there in the charge?
Yes, that I am showing, my lord. If my lord may come to annexure 1, but first of all, what is the charge? This is only one paragraph charge, my lord.
The departmental proceeding was an ex parte proceeding.
Yes, ma'am.
Notice was served, not served.
One notice I received, which I have replied, which I am admitting. Only one so-called notice I received, which I replied. Thereafter, I was not allowed to participate. I was not allowed actually to participate in the departmental proceeding, and neither, my lord.
Not allowed means who stopped you?
Actually, the notices were sent to some other address, my lord. Whereby I was not residing at all, my lord. Therefore, those notices did not come to my knowledge, and therefore I could not participate in the departmental proceeding and everything, my lord. Now here is a peculiar case, my lord. What has happened? Generally, a departmental proceeding, when it concludes, it culminates with the issuance of inquiry report. The inquiry officer submits his inquiry report. Now the inquiry officer submits the inquiry report on 4th of October or whatever it is, my lord. And very next day, that is 4/4/2008. He submitted his report, and the punishment order came on the very next day. That is 5/4/2008. So this shows two things, my lord. First, the disciplinary authority has the preoccupied mind to punish me, my lord. Second, inquiry report not given. Third, second so cause not given. So these all three aspects of the matter, my lord, culminates ki this is highly illegal. They cannot do such things. They cannot proceed against pass a major punishment, which is extreme violative of the police manual, my lord. Without service of inquiry report, without service of second so cause, how can a person be inflicted with a major punishment of dismissal from service, my lord? And that too, and if charge, I want to read, my lord, in Annexure 1. What is the charge? Page 21 of my writ petition. इन पे चार्ज है 59 दिन भगोड़ा होने का, अनऑथराइज्ड एब्सेंस. अब नाउ माय लॉर्ड,
please see the inquiry report at page
No, we
24.
will not be, you see, there is a serious procedural lapse.
Yes, my lord.
So there is no point. You will, now the inquiry report is on record or it is not there?
Inquiry report is on record,
Who
my
has
lord.
filed it?
This has been given along with punishment order after 4 months, my lord. Everything after punishment order. This is apparent from the facts itself. 4 तारीख को होगा, 5 को punishment होगा, तो inquiry report कब देंगे और second show cause कब देंगे, वो तो impossible.
That's true. Where is the date of the, where is the counsel for the other side?
My lady, what has happened?
On the last date also nobody was appearing on behalf of the state. Today also they are absent. Contract they will find.
Yes.
Have you taken any, where have you taken that no show cause was filed, was given to you?
This
the
is in the
inquiry
red petition itself, ma'am.
Where is it? Let us see their
Yes.
response to that. Because they are absent, right?
Para 27.
Para 27. Can you read it?
That on perusal of the order of dismissal dated 4/5/4/548, it is will reveal that show cause against proposed punishment or dismissal from service was not issued by disciplinary authority. And next paragraph further, it also reveals that the copy of inquiry
What
report
is their response to this?
Now the response to paragraph 27, I am reading here. One paragraph, para 18 to 39, everything replied in one paragraph.
Where is that?
Page 16 of their counter, para 27. That with regard to statement made in para 18 to 39 of the writ petition, it is most humbly submitted as a statement made therein are quotation of various judgments. Hence will be replied during the course of argument. So this is the reply to my averment, specific averment. And apart from this also.
Just a moment. Since when were you working?
Yes, I joined the service on 2005, 24/3/2005.
Also for the petitioner is present. Nobody appears on behalf of the respondents. This the petition has been filed for the following relief. Where is the appellate order?
Yes. That is annexure 4, page 27.
The order was passed on 5/4, and then you filed your appeal, right?
Yes. This I have stated, my lord, in the writ petition itself, that since the dismissal order itself was served to me very belatedly, my lord.
When was it served to you?
Yes. 30 onwards, my lord, I was still in 31.
You have not mentioned it in your memo of appeal. Yes.
Memo of appeal. Not have NS memo. Page 2 of my memo of appeal, page 29. फर्स्ट बॉटम लाइन में नोट कि बर्खास्तगी का सजा प्रदान की गई जिसके प्रति मुझे आज तक उपलब्ध नहीं कराई गई. In appeal also I have raised these issues, my lord. And several other 852, 847, 864 policemen or everything I have raised, my lord. But he simply.
Page number 29.
Yes, ma'am. First paragraph, bottom line.
This is the revision. This is the revision you have mentioned.
Yes, ma'am. This is memorial revision.
This is called memorial, right?
Memorial. And memorial revision has been dismissed कि उन पे petitioner का sign नहीं है. So this ground has been taken by the revisionist, my lord. Petitioner का sign नहीं है इसलिए इसको हम reject करते हैं. Only one judgment I would be relying, my lord, of this. This is a judgment of division bench of this honorable court. Exactly on the point of non-service of inquiry report and super's notice, second super's notice. Para 10, my lord, is specific of this judgment. Mr. Patel submitted that the petition is one of the ground of main writ petition and specifically about that no so-called notice along with inquiry report was ever served upon the petition after inquiry was conducted by the DSP. Whereas the learned report has not returned any finding on that aspect. According to Mr. Patel, it is a case of major penalty. Therefore, before passing the order of major penalty, supply of copy of inquiry report along with the second so-called notice is a must and thus legal issue is no more res integra.
The learned counsel for the prayer court, right? The learned counsel for the petitioner has submitted that the petitioner was appointed as constable in Jharkhand Armed Police -10 Mahila Battalion, Kotwa Ranchi, on 24/3/2005. And in the year 2007, she was posted at High Tension Factory Namkum Ranchi along with other police personnel. However, a charge memo dated 4/5/2007 was issued to her.
Charge memo is 6/8/2007. This is the inspection done on 4/5/2007.
However, a charge memo was issued to her
6/8/2007.
on 6/8/2007.
Yes.
On 6/8/2007, alleging that during checking on 4/5/2007 at 9:45 in the night, she was found absent from duty.
and remained absent thereafter for 59 days.
And remained absent thereafter for 59 days. The learned counsel submits that. Although the charge memo was served upon the petitioner, but subsequent notices in connection with the departmental proceedings were not served, and consequently the petitioner could not participate in the departmental proceeding which resulted in ex parte inquiry. He also submits that in the present case there has been gross violation of the procedure in the matter of imposing punishment, inasmuch as the petitioner has been dismissed from service without serving copy of the inquiry report and consequently without calling for any second show cause. He submits that the inquiry report was submitted. The inquiry report is dated 4/4/2008, and the petitioner has been dismissed from service on 5/4/2008. The learned counsel has referred to the statement made in the writ petition in paragraph 27 and has submitted that the said statement has not been denied by the respondents in the counter affidavit. The learned counsel further submits that even the dismissal order was not served upon the petitioner for a long time. However, as soon as the petitioner came to know about the order of dismissal, she obtained the same and filed an appeal before the appellate authority. However, the appellate authority rejected the appeal by recording that the appeal itself was time barred. He submits that the order of punishment of dismissal was 5/4/2008 and appeal was filed on the date.
In 2011, madam.
Appeal was filed in the year 2011. The learned counsel further submits that against the appellate order, the petitioner filed a memorial
revision
/ revision but the same has been dismissed by mentioning that the memorial did not contain the signature of the petitioner. The learned counsel submits that due to inadvertence, the signature was, the memorial was not signed, but the authority did not grant any opportunity to the petitioner to rectify the same error, but the fact remains that the memorial was filed by the writ petitioner. The learned counsel submits that considering the fact that the petitioner was neither served with the inquiry report and accordingly not served with any show cause in connection with imposition of major punishment, one opportunity may be given to the petitioner and the impugned order of punishment, the impugned orders be set aside. The Learned Counsel has also submitted that he may respond to the inquiry report. अभी आ गया आपके पास?
हाँ अभी inquiry.
He may be granted liberty to respond to the inquiry report within a stipulated time frame.
They will second
Okay,
so cause.
all right. The Learned Counsel submits that the respondents be directed to issue the second show cause to the petitioner so that the petitioner may respond to the same and appropriate order can be passed.
After proper opportunity.
आप hearing second show cause के बाद नहीं, you will just respond to your.
हाँ ठीक है.
ऊपर लिखिएगा, the Learned Counsel has also submitted that the opposite parties have taken extraneous material into consideration to impose at the stage of inquiry and to impose punishment, and therefore the petitioner has been prejudiced by the conduct of the respondents.
And subsistence allowance also not paid, madam. That is also by because that is my right.
The Learned Counsel has also raised a grievance that the petitioner has not been paid the subsistence allowance. 3 साल तक क्या कर रहे थे? घूम रहे थे. होश नहीं आया कि ड्यूटी करना है. टाइमली ज्वाइन करते तो पता लग जाता ना. Right. So भगौड़े तो आप हैं, इसमें कोई डाउट नहीं. Anyways, after hearing the Learned Counsel for the petitioner and going through the materials on record, including the counter affidavit filed by the respondents, this court finds that admittedly the petitioner was, admittedly the inquiry report was submitted by it. Inquiry report is dated 4/4/2008 and the punishment has been passed, major punishment of dismissal from service has been passed on the next day, that is 5/4/2008. It further appears from the records that neither the inquiry report was given to the petitioner prior to passing of the order of dismissal, and consequently no second show cause was also issued to the petitioner. And therefore the provisions of Article 311 within bracket 2 of the Constitution of India has been violated. It further appears that the petitioner had filed appeal in the year 2011, but the appellate authority has dismissed the same by stating that the petitioner was not served with a copy of the order of dismissal officially. However, the memorial was unsigned and the respondent authority had dismissed the memorial while recording that the memorial was not signed. And has also recorded that the appeal was barred by limitation. At no point of time the authority had pointed out the aforesaid error, that is absence of signature in the memorial, to the petitioner so that the same could be rectified. However, it is not in dispute that the memorial was filed by the petitioner. Considering the totality of facts and circumstances of this case and the fact that the petitioner was neither served with a copy of the inquiry report and nor was granted any opportunity to show cause, nor was issued any second show cause prior to imposing the major penalty of dismissal, the impugned orders passed by the authorities cannot be sustained in the eyes of law and are accordingly set aside. However,
My lord, this is the para 20 and 21 of the judgment which I just read, my lord. Same thing happened, and what was the effect of punishment of this dismissal that is stated. Para 20 and 21. Last page. I will open to respondent to initiate
आप कुछ
procedure.
ज़्यादा ही नहीं मांग रहे? Yes sir, this is absolutely the
नहीं, from the
prerogative
stage of
of
service of second show cause ही बोल रहा है यहाँ पे. वहीं बोला जा रहा है.
ये सब हम कुछ नहीं कर सकते. The respondent authorities shall take up this case by issuance of second show cause notice to the petitioner. यही एड्रेस है आपका?
हाँ, अभी जो रिट पिटीशन में.
यही एड्रेस है ना? हाँ. At the address which has been provided by the petitioner in the writ petition, the counsel for the petitioner has submitted that the address mentioned in the writ petition is the present and correct address of the petitioner. The needful be done within a period of 1 month from the date of receipt of a copy of this order. And appropriate order be passed considering the second show cause reply, if any, which may be filed by the petitioner within a period of 3 months. The petitioner shall produce a copy of this order along with a copy of the entire records of the state petition before the respondent number 1 को चीफ सेक्रेटरी को पार्टी बनानी है.
Before commandant Jeff did, my lord.
Before the respondent number 225 सबके पास प्रोड्यूस कर दीजिए. ठीक है. This court has not gone into the merit or otherwise of the case of the petitioner. The impugn orders have been set aside only on account of the fact that the petitioner was neither served with a copy of the inquiry report nor served with any show cause notice prior to her date of dismissal. This petition is accordingly dismissed.
Item 6, WPS 6497 of 2016.
Yes. What is it? Petitioner, are you there? What is the matter about?
Petitioner challenged the order of dismissal. I don't matter about. I was constable in JAP 8 Lamu, Jharkhand Armed Police Lamu. I was dismissed first time, twice for the same cause of action. First I was dismissed in 2009. That dismissal was quashed by an XF2 by law, by DGP. DGP had directed some direction was given to the commandant and DIG. You make a fresh inquiry on certain points. Page 28, my lord, the direction of DGP, 28 page, my lord, Annex 2. और लास्ट टाइम डीजीपी ने आदेश दिया है कि जांचकर्ता का बैंक के खाता की जांच नहीं की गई. जो शिकायत करता उसकी बैंक एलिगेशन था कि हमने 9,000 रुपया अपने कलीग सुनील कुमार के बैंक से निकाल ले लिया है. यही एलिगेशन था बैंक में. तो मेरे अकाउंट को चेक किया गया. मैंने सेवरल मंथ से
There are two things. One is on the merits, and other is the sequence of events. You said
I'm
that you have been dismissed twice for the same.
No,
First you narrate the sequence and then you.
No, I am giving sequence, my lord. तो सीक्वेंस डीजीपी ने लिखा माय लॉर्ड कि विभागीय कार्रवाई के 28 पेज में है माय लॉर्ड. उपयुक्त लिखित त्रुटियों के मद्देनजर रखते हुए अपचारी ओमकार कुमार ओम के विरुद्ध इस विभागीय कार्रवाई को पारित आदेश को निरस्त करते हुए अपचारी को पुनः सेवा में लेने का आदेश दिया जाता है. और पुलिस उपनिरीक्षक समादेष्टा पलामू के उप त्रुटि के लिए.
You were reinstated and your disciplinary you were reinstated primarily because of the reason that there was principal violation of principles of
जो इंक्वायरी के प्राइमरी.
That's like whatever it is, you were reinstated and they were supposed to take appropriate course.
Yes, my lord.
Okay. Then what happened?
Then again they have set up another inquiry officer. They have joined me. They have allowed me to join the service. I have joined.
Okay.
After that, they have started another inquiry.
Is
in which next
is mentioned is विभागीय कार्रवाई को पुनर्संचालन के पश्चात. So there was a direction of fresh inquiry.
Fresh inquiry.
Yes.
और विभागीय कार्रवाई को पुनर्संचालन के पश्चात के क्रम में लिए गए निर्णय के आलोक में अपचारी की सेवा से बर्खास्ती और पुनर्जुगान की तिथि के बीच का अवधि का निर्णय लिया.
That's right. That's right, because the differential payment
My
will depend upon what will ultimately happen in your
So
disciplinary
inquiry,
proceedings.
I have joined, inquiry was set up, the inquiry officer has proved, submitted the inquiry report and they have.
Did you participate in the second round?
Yes, my lord, I have participated and they have found, inquiry officer found no guilty.
Where is that? Where is
Next
the report of the inquiry officer that you were
Annexure
not
5,
found guilty?
my lord, page number, Annexure 5, page number, my lord, page
You were
number.
not found guilty?
36, page number 36.
Okay. You were not found guilty, right?
Then disciplinary officer again, they have some, again,
He can differ with the inquiry report. He differed with the inquiry report?
Yes, and he appointed another inquiry officer.
Oh.
Or he has taken, he has kept that inquiry, first inquiry report in abeyance. He has not passed any order. Second inquiry report, I have been declared guilty and I have been dismissed within 7 days.
As per disciplinary authority,
And
certain documents have not been considered by the conducting
My
officer.
lord.
Lordship. That's why another new conducting officer has been appointed, and there.
Is it permissible?
Lordship, that has
Not
been
permissible.
You will go on making fresh inquiry till one of the inquiry officer finds him guilty.
Lordship, that has been done, Lordship.
So
I
how
can't
do you
say-
defend it? Should I record that you concede?
Lordship, it is on record, Lordship.
Then you concede. It's on record. You are
It's
here
on
to
record,
argue
I
a
can't
case.
do it anymore.
The court proceeding is live. Your client must be watching you.
Yes, Lordship.
You want to concede?
No, Lordship.
I'll record your concession.
As per the finding, there were several documents which should be considered by the conducting officers, and the same has been not considered by him.
So then also the disciplinary authority had the jurisdiction to differ with the inquiry report and give his own opinion regarding the inquiry report, and then he could have proceeded.
Yes, Lordship.
But he instituted a fresh inquiry.
No, not fresh inquiry. The same.
Fresh inquiry?
It was.
Yes, my lord. Another DSP one.
You are not on the same facts. Facts are different.
No, conducting officer has been changed, Lordship. But
Same
inquiry.
thing.
inquiry
Conducting
proceeding
officer
was-
has been changed, or the inquiry officer
No,
has
Inquiry
been changed?
officer, that is inquiry.
Conducting officer, Lordship.
That is inquiry officer.
That is inquiry officer. But the inquiry proceeding was same. It was not different.
No, I don't know. The inquiry officer was changed.
Yes.
And you say that the inquiry proceeding was same.
Yes, same inquiry proceeding.
No, I don't get it. Where is the order of the disciplinary authority for further inquiry? Where is that order? Did he ask for further inquiry? Or he asked for a fresh inquiry? Have you got those judgments? Leke aaye hain aap judgments. Yes, counsel for the petitioner.
Yes, my lord. I have submitted one judgment.
Which judgment have you submitted?
दो जजमेंट लाए हैं मुझे पहले उस पर इंश्योरेंस मांगा गया था जो उसमें लगाए थे और फिर इसको और लाए हैं
The law is well settled. There are judgments of the Honorable Supreme Court on this. Where is the order of the disciplinary authority asking for fresh inquiry or further inquiry?
6 my lord.
Where is that? Page number?
Page number, like my lord, page number 39.
39. No, this is the inquiry. Where is the order of the disciplinary authority asking for further inquiry or fresh inquiry? Where is that order?
DGP का ही आदेश पर उन्होंने
Where is that order?
28, page number 28.
28.
Last slide.
No. This, you see, after this page number 28, there was fresh inquiry,
Yes, my lord.
right? You say that as per the fresh inquiry, the inquiry officer held that you are not guilty.
Yes, my lord.
Thereafter, there must be another order by which further inquiry or fresh inquiry was done.
No further order. On the basis of on the basis of the order of the DGP, they have started so much.
Now how? The order of the DSP has already taken its effect.
My lord.
There
They
is-
on the basis of the order of the DGP.
There is already a fresh inquiry done, right? And after that inquiry, why further inquiry was done? Under whose order it was done? You are absolutely clueless.
No,
You don't know your facts.
but no order is passed by anybody else.
How is it possible?
But I didn't-
How will any other officer dream that he has to undertake further inquiry or second inquiry? How is it possible? You are not clear on facts. You are not clear on facts. We can't do anything about it. You get ready properly. And this is not the judgment. There are other judgments also on this.
Yes, my lord, I will bring that.
Where is that judgment? Our High Court's judgment is also there. Supreme Court's judgment is also there. That there cannot be repeated inquiry till the person is found guilty in the inquiry proceedings. You have been doing so many police personal matters,
Yes,
and you are not aware.
Aware, my lord.
Where is the judgment?
Another judge, second inquiry, same charge cannot be.
Where is the judgment? Show me. What is the
Citation, my
name?
lord, citation,
Name,
2007,
Name.
volume number 11, SEC, page number 517.
Name of the party.
Name of the Kanar Lal Vera versus Union of India as address.
No, there are other judgments also.
There are,
Later
but I have not
judgments.
brought, my lord. I will bring.
You are not aware.
I am aware of what I know.
Yes, what do you have to say? He says that there is further inquiry. Where is your counter affidavit?
Lordship, counter. There is a counter.
They were next
Both
one.
of you please get ready.
Lordship, can we see para 12 of the counter?
You are not ready. You are not clear on facts. You are not on the same platform. He says that fresh inquiry was conducted. You
Yes,
say
fresh
further
inquiry.
inquiry was conducted.
No, not further. A fresh inquiry was conducted, and in that inquiry, the inquiry officer has given clean chit to the petitioner,
Yes.
and the disciplinary authority differed from the.
Where is that? Where is
It
that
on
order of
paragraph
the
12, Your Lordship.
Para 12?
Yes, Lordship.
It has to be a letter, no?
Lordship, letter has not been annexed.
Where is that letter?
Letter has not been annexed.
You bring it on record. That's such an important letter.
Okay, Lordship.
The learned counsel for the parties are present. During the course of argument, it has been submitted by the learned counsel for the respondent that initially the punishment order was set aside on account of violation of principles of natural justice with the direction to conduct fresh inquiry. He further submits that thereafter fresh inquiry was conducted and the petition and the charges were not proved as per the report, and subsequently the disciplinary authority differed with the finding of the inquiry officer, but the letter by which the disciplinary authority differed with the finding of the inquiry officer is not on record. The learned counsel for the state is directed to seek instructions and file a supplementary affidavit in the present case, bringing on record the aforesaid letter of the disciplinary authority and also any other documents which he finds relevant for the purposes of this case. Post this case on 8th of December, the supplementary counter affidavit should be filed by 4th of December. Record मंगा के रख लीजिएगा, right?
Original record.
Yes, you should bring it. Keep a copy for yourself.
Yes.
Item 7, WBC 6781 of 2016.
Yes, what is the situation?
My lords, on the previous occasion, the trial court record was called for by my lords, And
We did not call for trial. The stage of the case.
yes, state of the case.
What is the state of the case?
There is a compromise between the two.
Okay.
And the respondents have also filed a IA regarding that, my lords. IA number 10,258.
Okay. So you
And
want
they have
the
stated-
case to be.
It has basically become infructuous also.
मेन ओरिजिनल सूट जो है लॉर्डशिप को विड्रॉ कर लिया गया है रिस्पोंडेंट नंबर 2 से.
All right. Thank you.
And the petitioners have also come.
So therefore this IA has been filed.
IA already filed.
Title suit has already been withdrawn.
Yes, Lordship.
This case arises out of title suit.
Title suit ने original suit number 318 of 2016.
Okay, original title suit.
Yes, Lordship.
Counsel for the parties are present. IA number. Yes, madam, you are the mother.
Yes, please.
Ah, बड़ा हो गया बेटा. That's good. How are you? Good. Happy? You want anything from the court? Think of it. तुरंत ना बोलने की जरूरत नहीं. You want anything? पढ़ाई हो रही है? In which class are you studying? Class. Which school? Sharda. How is your result?
Not so good.
Why? You are not interested in studies.
Business.
What is it you like? You like business? So for doing business also you need to study. Isn't it? पान दुकान खोलने के लिए भी जो है ना ग्रेजुएशन तो होना पड़ेगा. You can get many aid from the government, right? I'm telling you, right? You can get many aid from the government for the purposes of opening a business you want to. You can have your startups बहुत हैं आजकल, थोड़ा सा दिमाग लगाओ, right? And do well in life. Past is past, उसको भूल जाने. उसको याद रखना है इसलिए क्योंकि फ्यूचर बढ़िया हो जाए. Okay? And if you need anything at any time, you can just come to our Legal Services Authority, Jharkhand State Legal Services Authority. They will do whatever they can do for you. There are lots of schemes for it. Right? Waiting for you. Schemes are waiting for you. Okay? IA number 10258 of 23. Counsel for the parties are present. This petition has been filed, bringing on record that the matter has been settled between the parties and a prayer has been made to dispose of the petition as the original title suit number 318 of 2016 has already been withdrawn by the present respondent. The counsel submit that nothing survives in the present written petition. After hearing the counsel for the parties and going through the interlocutory application, the apparently nothing survives in the present petition, and accordingly WPC number 6781 of 2016 is disposed of. Is there any interim order? Was there any interim order? There was some FD etc. There was some fixed deposit.
No.
Already paid.
Once she was paid 50,000.
Yes. Nothing more?
No, nothing more was there.
This writ petition is accordingly disposed.
Item 8, PS 5107 of 2017.
this petitioner, he was appointed in a college which was affiliated college and not a constituent college at that point of time. He was appointed on the post of lecturer in English. Thereafter, the college was taken over as a constituent college, and the petitioner continued in the service of the college, and he retired after completing 39 years of successful service, unblemished service, in 2016.
What subject was that?
English. And in between that service period, he was also appointed as controller of examination of the university, proctor, and then he was sent for various refresher courses, UGC courses and other courses. All these things were there. During his service tenure, sometime just 5, 6 or 7 years before his retirement, it transpired that his services are not confirmed. Then the petitioner moved this honorable court in the first round, and that writ application was allowed by quashing the order by which the Vice Chancellor denied confirmation of his services. It was remanded for taking a decision in accordance with law. Now the university statutes are framed under the provisions of the Bihar Inter-Universities Act. There was a statute for regularization which was operating in 1986, and that was applicable in cases of cases like petitioners for regularization or confirmation, as the word says in English. Then there was, under that scheme, a committee was formed to consider the cases. That committee has nominee from the state government, university, from the Chancellor's office. That committee made a recommendation referring to the fact sheets of the case of the petitioner. The matter was before the Chancellor. However, from the office of Chancellor, his claim for regularization has been turned down for a reason that at the time of his initial appointment, this petitioner did not possess high second class master degree, which was the requirement at that point of time.
At the time of initial appointment?
Initial appointment.
By that private college?
That private college. Now, that is the only thing which is the basis of that rejection. That rejection has, order has been passed during pendency of this writ, and therefore it has been challenged by way of amendment. The amendment writ petition has been filed. Now the petitioner's contention is that, basically the legal contentions, is that throughout the service there is, admittedly there is no
suppression.
No suppression. That was I was going to. Admittedly there is no suppression.
No fraud, no suppression.
No suppression, no concealment, no fraud on part of the petitioner.
So you are pleading waiver? Waiver of any kind of objection regarding your
waiver or estoppel, that principles may also apply. And after recognizing, after taking his services, and one thing is very important, this college did not remain mere affiliated. This was taken over as a constituent of the university. The moment the exercise of constituent is a statutory exercise in accordance with the provisions of section 41435. At that time screening is done. The petitioner's service was also taken over, meaning thereby the petitioner's service was approved. That is itself enough to consider his case. And thereafter the petitioners.
When did this happen? In the year?
The constituent, I'm just giving the list of dates also. The college was
long back.
Yes, he's 78, 1980.
Just a moment. Mr. Singh, you can rise from the slumber anytime you want. Isn't it too harsh?
The university is fine.
Is there any allegation of fraud, misrepresentation?
No, I'm not saying. University has filed a counter affidavit.
Thank God that you are not recovering the entire amount from him after his death.
He's not dead.
No, he's not dead, but he might. Everybody has to die one day. You could have
Virtually-
realized your mistake after a very, very long time, when the employees is also dead, and then you start recovery proceedings.
Virtually is on deathbed, not getting anything.
Yes, please hold on. Yes, you just tell us that what is it which deprives a petitioner from equity?
My lord, I am not a counsel for the office of chancellor first.
Who is appearing for office of chancellor?
The order.
Are you? Okay, I'll ask you first.
Because the order under challenge presently is the order of the chancellor.
Let him just address for 5 minutes. We'll certainly adjourn this matter, but you should give it a thought.
Yes.
Right? Is the equity in his favor completely?
Equity follows law, madam.
That's right. Otherwise, equity is in his favor?
Otherwise, we will say that to that extent we can say that because he has not misrepresented. But then law mandates an act has to be done in the manner prescribed.
Does the law also mandate that you have to take appropriate steps at appropriate time?
So when he has come up at this stage for regularization in 2017.
Because it was never pointed out.
No, the question that survives that he was not qualified for his appointment.
That's right.
And he continued for his work, he has been paid. Now he wants that he should be placed at parity with other teachers
Why
for
not?
retirement benefits.
Why not?
So once, my lord, that goes to the root. Equity, my lord, 226, my lord can exercise. But so far as this office of chancellor is concerned, we have to stick to the laws to apply to his case. And my lord do not permit, I have to remain stuck in the because that
you have filed your counter affidavit?
Yes, I have filed a short notes of argument also, my lord. Written submission on 3rd of July 2023.
Yes. Pursuant to that order, the petitioner has also filed a short list of dates.
I just have
And
one list
my-
of dates. Where is your note?
My lord, I have filed it on 3rd July 23.
3rd July. This matter is assigned to me?
Yes. Yes. So if that is not there, again you can give a copy to me.
Please provide us a copy.
Yes, ma'am. We'll give
And
it.
please put your name at the top.
Yes,
Right?
I think this copy would be there, Lordship. This is the this copy has been given.
Ours is like this.
Along with
We
the
have
details of the
forwarded-
cases being relied upon, cases and the issues of law. That is
I have this only.
Normally, ground power covers the file for this year.
You have filed it in the registry.
Yes, ma'am. That's what we were directed with. It will be the last document in ground cover.
Written something.
Yes, that is that. 3rd July, madam. So we have formulated the issue, madam. So far as equity is concerned, madam, that is 226, madam, Court of Law and Court of Equity. My lord can always expect the scope, but so far as myself is concerned, Office of Chancellor, we have given that, madam. If 3 paragraphs can be seen.
The order of a college being taken up as a constituent college and the required scrutiny done by the university is ultimately penned by the Office of Chancellor.
The appointment for lecturers.
No, even for declaring that a particular college will be a constituent college and these professors or lecturers will be appointed accordingly or maybe absorbed accordingly. This exercise is also done by the Office of Chancellor. No, why do you need to take
No,
instructions?
these questions are specific, madam. So because matter is
Mr.
going to
Singh must
stay-
be knowing, he is
Yes,
very expert.
he might,
This exercise is also done.
Not at the level of chancellor, members. The state government of education decides that the following colleges in the university will be taken over as a constituent unit.
That's right.
Once that order is issued, in view of the provisions contained under section 4.114, the absorption of a staff and all basics is done by the university, not so much by the office of the chancellor.
But not ultimately placed with the government.
Yes, they remain there with the consent of the university and government, there is no doubt about it. Office of Chancellor, whether the entire matter is referred to, I have doubts. The entire matter is not referred.
That's why even if it is not referred, but it is within their knowledge and domain.
The copy is forwarded. The notification shows that the copy is forwarded to
Mr.
the.
Singh, he has got nothing to say on equity, he is only on law. What do you have to say on equity?
My lord, I cannot deny that we kept him right from 80 up to 2017 and took work from him. The only point that has been raised by the Office of Chancellor, the university, I must point out to my lord, has already recommended the regularization of the bill. It is there in my counter affidavit.
Okay, so you are in support.
We have said, let me clarify certain things. Petitioner did not meet the minimum eligibility criteria as given in the advertisement at the time of the appointment. We have said it. We have also said that he did not have the minimum prescribed 52.5% in his postgraduate result at the time of appointment. We have noted. But having noted that he has remained in the university for so long, we have said that he should be regularized. That is our recommendation. We have recommended that to the Office of Chancellor. And the Office of Chancellor has said, since the advertisement prescribed minimum 52.5 marks, whereas you had only 46% marks, so the Office of Chancellor does not approve the provision of regularization. My Lord has asked a specific question to me, what do you have to say on the equity? The equity is entirely on the side of the petitioner. This honorable court
Now
has-
we will have a judgment on equity.
My Lord, this
You prepare yourself on equity. Because there is no doubt that he was not qualifying on the date of
appointment, there is no doubt about that. We have also noted. In this case, in
एक equity का judgment होना चाहिए.
होना चाहिए. Because ultimately when our constitution came, Court of Chancery and Court of Equity both merged in 226, and I am also expecting a judgment.
So you prepare yourself on
yes,
equity.
But
And then-
ultimately, I was going through a judgment. It says that equity has to follow law. So ultimately, equity cannot be in deviance with law.
Law also follows the equity.
And that's vice versa. So then law has to come to the test of equity.
Law has to come
To the test
to
of
rescue
rescue. Yes.
people who have acted fairly, without any suppression, without any fraud, and that is why 226 is there.
I
will assist, well, I will not resist. I will assist my on the point.
I will just
in the interest of justice.
Only one judgment of this honorable court, which several up to Supreme Court. In Ratni Orao case, in my university, Kolhan University, that was a case of a person who was definitely appointed on an unsanctioned post, and he remained.
Kindly
on a-
give me that judgment.
Yes, yes.
Earlier the better. आप उसको mail कर दीजिए please. उसको लगा देंगे
I will just end up in.
But I have referred all the judgments in my notes, and it are also enclosed.
Including this judgment?
No, not Ratni Rao is not there. On point of equity also, with my last supplementary affidavit.
थोड़ा सा और काम करिए. Equity में इतना आसान नहीं है.
All the copies.
You do more work.
I will place all those which are part of the supplementary affidavit.
Like 226 relief can be denied even if you have a case,
if you
but
are not-
equity is not in your favor.
You have not come with clean hand.
226 can be denied.
Yes, yes.
So 226 can be allowed. If you have come with clean hands, your act is absolutely bona fide, no allegation against you, then 226 relief I think can be given.
I mean, that says valid to that extent that without making it a precedence in the present facts of that goes to that extent.
Why the principle of equity will not be treated as a precedence?
That goes when my lord exercises.
Equity will certainly depend upon the facts of each case.
Yes, that is there.
That has to be there.
That is
So, equity as a principle can be treated as a precedent, but it will depend upon the facts and circumstances of each case. So, you can always distinguish.
Principles are common. It depends upon the factual matter.
I don't believe in writing a judgment and saying that it will not be treated as a precedent. It will be treated as a precedent.
In a given
you can
fact,
distinguish on facts.
Identical facts it will.
ये दोनों जगह में निकाल के अलग करके ऊपर लगा दीजिएगा और उसमें लगा दीजिएगा written submissions file और सिर्फ equity लिख दीजिएगा बस.
So
we'll hear it on the next.
Yes, because two things will follow. That under
The
law, the right is
council
not.
का appearance record करिए. The councils have advanced their arguments at length. The claim of regularization of the petitioner post-retirement has been denied by the Honorable Chancellor on the ground that at the time of appointment of the petitioner, he was not possessing the required qualification to the extent that he had 52 point.
He had 46.
He had 46% in his post-graduation, and the minimum requirement was 52.5%.
Yes, exactly.
The councils have also advanced their arguments on the point of equity, in as much as admittedly there is no allegation of any fraud or misrepresentation on the part of the petitioner. Post this case on for further hearing on opening Friday.
My lord.
Pathard.
Opening Friday.
Pathard.
My lord. Otherwise also it is a sign.
Your matter could not be taken up. Today is the last working day. After this matter, on the next day, we will start with the proceedings as well.